Hey, let's begin on a light note this morning, shall we? It's what day is it? Tuesday, and we're inching our way through the week. Tomorrow will be Hump Day. That's the day we celebrate camels, I suppose, and then we'll ease on into the weekend. And before you know it, another week will be logged. But yet, let's not wish our lives away. Let's live it one day at a time and cherish the gifts we are given. Story out of Lee County. It raises a question.
Looks like we're having trouble over on Rumble. Surprise, surprise.
Oh, Rumble, come on back. Rumble. Hello, Rumble. Can Earth to Rumble? Hi, this is Norm and Mike from Law and Legitimacy. We would like to rumble in the jungle. Can you please get your shit together, get us online so we don't waste our precious minutes spitting airs into the ether, into the void, expecting a response when all there is chaos? We know better. We are humans who crave significance, and guess what? We are significant, even Rumble, if you can't get your ass out of your electronic asshole. I mean, should we just move on and forget Rumble today?
I fixed it in your you giving me a few seconds there. We're good.
All right. So anyhow, Lee County, Florida, there is a criminal case pending that raises, well, quite frankly, a serious question. I mean, it's serious. It's a question that everyone, especially young men, sometimes even older men, have pondered.
How much too much?
Is there such a thing as too much pussy? Now, I'm referring, and now I know you dirty-minded people, you thought I was being lascivious. You thought I was referring to some libidinal activity. Women are scandalized. Dawn McNeil's probably over there in California with her head exploding, stringing her pickleball thing up, saying, I got to get out of here. I can't stand this guy. But you love me. You know you love me because at the end, I'm speaking to you from the dark libidinal core where desire and love defines the world. So here's what it is. Lee County, Florida. Man gets evicted from his home on or about March 4th or so. And someone takes him in and he brings his 3 cats with him. Now, it turns out she's not a cat woman, but he is a cat man. And so he brings a cat home each day.
I got a cat.
I've got news for you. Kibbles and bits, And so in he walks one day with the 9th cat, and they had a fight. She took him in, and she's got now him and 9 or 10 cats, and he shoots her. And the story in the Miami Herald is that she survived, and the fight that led to the shooting was over cats. And you're saying, why are you talking about this on Law and Legitimacy? I'm telling you, it's because I sit in a law office in New Haven, Connecticut, fielding calls, frankly, from all over the country, primarily Connecticut, about things that go bump in the night. And people end up in the hands of the law, expecting the law, and the law expects to resolve them. Some poor lawyer is going to get a call, and he's going to be asked to defend this man. And he's going to be asked to defend this man against charges of, I guess, attempted murder and assault in the 2nd degree. And what's the defense going to be? She didn't. I mean, and what was the state of mind that led to this?
I was waiting for a 9 lives joke.
What's that?
In the cloud says I was waiting for a 9 lives joke. That may have been the legal defense here.
Yeah, I hear you. I get it, but I don't know what the defense is going to be here. I'm glad I don't live in Lee County, Florida, because in Connecticut, whenever something bizarre happens, I know there's a 75-80% chance that I'm going to get the call and have to deal with it or choose to deal with it if I want. I just can't imagine. So I offer it to you, those of you who think that the world is dull, boring, and that you wake up in the same humdrum confines day after day, required to repeat the same problems, the same issues. What's insanity? Banging your head against the wall every day and expecting a different result. Those of you who are tired of the insanity, I want you to know that just on the other side of your tedium, there is chaos. So be careful what you wish for.
This story is interesting to me, Norm, because I think about the circumstances leading to the two of them sort of cohabitating for a short time there. We know now that the guy had been evicted, right? So that gives you some idea of his motivation or some sort of exogenous pressure being applied to him, right? The fact that he's got financial difficulties, he can't stay, he can't make payments on wherever he is. And then he brings with him three animals, right? 3 domestic animals, 3 cats. And then each successive day that he was in the house, he added another cat. And so right here, I'm making some sort of psychoanalysis, right? And it's highly imperfect. But what I'm looking at is someone that is desperately looking to exert control over his own life and be needed and be wanted, right? Because animals need you to feed them, they need you to care for them, they give you back that affection. And then the person that he is now rooming with accepted maybe 3 of them, but at some point drew the line and said, these got to go outside. I can't have 6 cats in my house. To which he responded in a way that was actually more motivated out of what, like self-preservation, not some sort of, shallow argument over I don't like you, or that was some sort of transgression against my personal property. These cats represented a little bit more than, some sort of feline companionship under the circumstances. So no good deed goes unpunished to the homeowner. I think it's miraculous that this homeowner actually is going to be alive to tell the tale of this, being shot.
Well, I can't wait to hear it. And I guess
in the ribs and the arm, like I think one of her middle fingers was shot off, or the tip of one of her middle fingers was shot off. And the guy knocked the phone out of her hands when she was going to go call 911 and then relented and called himself. So that was a very, very close call for her, for sure.
I don't know. I mean, here, in case you're wondering what this segment is about, folks, it's Norm and Mike playing armchair psychologists. Why? We don't need an MD. We don't need a PhD. We don't even need training in clinical psychology. We don't even need to be social workers. We just need to be 2 guys with hearts alive to the passions that move the world to recognize that this guy's fucked up, And so if I'm his lawyer, I'm thinking, probably need a competency exam because there just ain't something right in the
So I think we meandered into the answer to your question originally, which is, what kind of legal defense are you putting on? And it has to be some sort of competency exam. There has to be some sort of, and it'll be a justification. It won't remove him of guilt, right? But it will excuse some sort of sentencing, I'm assuming.
It is the too much pussy case. So we'll keep an eye on it. We'll purr on as events unfold. Hey, Fani's legal troubles aren't over. And I am impressed with Trump's legal team. About the time you think, about the time you think he's done, he winds up, takes a deep breath, and manages to advance his litigation yet a further step against potentially all odds. The Trump legal team is filing an appeal of Judge Scott McAfee's denial of the defense motion to disqualify Fani Willis. And I think that's probably a good move because McAfee's decision was relatively incoherent. It was unfocused. It gave a little bit. It did what weak judges' decisions do.
Promised something carefully worded, though, Norm.
He tried to give a little bit of something to everyone, and what he created was confusion. And so I think that what he said was, there's a scent of impropriety here. There's some candor issues. One of them's got to go, but the defense didn't prove prejudice. And what we said yesterday, as we discussed this briefly, is, come on. You've got a minister of justice who arguably engaged in something like lack of candor toward the tribunal. That should be disqualifying per se, because if she's going to lie with respect to her own interests, how can she be trusted to serve the people's interests? So, I haven't seen the appellate paperwork. Candidly, yesterday when we discussed the case, it didn't occur to me that there could be an appeal. But Mike showed me this story several hours ago, and I've had a little bit of chance to think about it amid everything else. And here's what I think. Here's how I would begin the research on this. First, you have to ask what the standard of review is. So, for example, an appeal is asking a superior court to review a decision by an inferior court, the appellate court reviewing a decision from the trial court. Trial courts make decisions on the facts brought before them, which they accept or not, and then they apply the law as they understand it to those facts. And so when you're taking an appeal, you're asking the appellate court to look at the record assembled in the trial court through a particular prism or through a particular lens. And that lens is called the standard of review. Now, there are 3 of them that are potentially applicable here. One would be a clearly erroneous standard, and that means that the judge made findings of fact that are simply wrong and that no reasonable jurist could have made. He concluded that the earth was flat when in fact everyone believes it to be round, or vice versa. In these conspiratorial times, I remember when I had a radio show, I once interviewed a flat earther, and I was astounded by the fact that there could be such people, and he was astounded by the fact that there couldn't be. And so, maybe, maybe that would be one thing, that he made clearly erroneous factual findings. I don't know that he did. The second is that he abused his discretion, that he had a choice about how to apply the law, but his choice was one that no reasonable jurist would make. The courts, the appellate courts, take a highly deferential view to trial courts' factual findings and conclusions. Abuse of discretion is almost an impossible standard to win on. The court could, the issue could be framed that while the judge found the facts to be true, his application of the law was an abuse of his discretion. I don't think that standard fits here either. I think the third standard is what will likely be the one raised, and that is de novo review. That is fresh review, that the appellate court gets to look at the record before it and make its own conclusions, both as to the facts and the law. And I don't know, candidly, whether de novo review will be applicable in this case. I don't know Georgia law. I don't know what precedents exist with respect to application of Georgia law. But I think that in this case, de novo review would be appropriate. And the question presented then would be whether, on the facts presented in this case, a court should conclude that Willis should be disqualified as an incapable minister of justice. That is to say, that she, because she lied, and because the record makes it abundantly clear that she lied, she should therefore be disqualified independent of any showing of prejudice to Donald Trump. And this is where McAfee tried to let the state of Georgia have it both ways. He suggested that she lied. There was a stink factor in the room, but the defendant hadn't put on enough evidence to show prejudice. I think that's where the sweet spot is in this appeal. And the court has to say, look, when a minister of justice, whose role it is to strike hard blows but fair blows, is found to have engaged in lack of candor in a particular case on any issue, that prosecutor should be disqualified from prosecuting that case entirely, because especially when their personal interests are involved, as they were here with respect to her love life. So, kudos to the Trump team.
Yeah. So here's sort of a structural problem, I think, that, and I'm not sure how big of an issue this will be, Norm, but I understand that Georgia law requires that if there is a motion that needs to be heard before trial, and I'm sure you're familiar with this, but the judge actually has to issue a certificate of immediate review, meaning that the Trump legal team has to petition the court that made the ruling that they're now challenging. They need to be granted leave of court in order to submit the appeal to the appellate court, which would then have its own discretion as to whether it would take it up on review or not. So there are two steps here.
Yeah. So
I wonder for his purposes whether he even wants to deny that leave.
Well, each state has it. This is a procedural issue that is unique to each state. And I don't know Georgia law, but I can tell you how that works in other states, in particular in Connecticut. So there are certain types of post-conviction relief in criminal cases called habeas corpus petitions. If you lose a habeas corpus petition and you want to take an appeal, you have to get a certificate of appealability from the trial judge. The judge has to say, okay, you can appeal. If he denies it, then you go ahead and file the appeal anyway and say he abused his discretion in denying the appeal, and here's what you should hear. And so you get to the appellate court anyway. So I think the Trump team needs to just not get hung up on speed bumps in the road and just motor on through to the destination. There is, in some states, and I know in particular in Connecticut, there is something called a special interest, a public interest appeal, that allows you to bypass the normal rules of appellate procedure and go right to the state Supreme Court. And so in Connecticut, if you, I've had two of those granted in recent years. Once in the Alex Jones case involving a sanction imposed on him, we thought in violation of the First Amendment, regarding a broadcast statement he made about opposing counsel. I also had this arise in the Fotis Dulos case with respect to a gag order that was placed on me for my outspoken conduct during that case. And in both cases, you write a petition to the Supreme Court and you say, look, there are vital interests in this case that the public has an interest in. And in those two cases, it was the First Amendment. And it's critical that they be heard now, independent of anything else that happens in the proceeding. And, stuff happens. And I would argue that whatever the procedure is in Georgia law, that's where we're at here. Because now we have a potential prosecution that could derail a presidential campaign of a man who has tens of millions of supporters and will be the Republican nominee for president. I can't imagine a more compelling public interest than that. And the question is whether his right to due process, whether his right to a fair trial, under the 14th and 6th Amendment, is being abridged. And fifth, and so I think I don't worry about that. And those who are raising questions about it, I mean, the common law varies from state to state. The legal doctrines that govern these procedures vary from state to state. But the felt necessities of needing to move the litigation along do not. And so I'm not worried about that at all.
Well, there's, I do commend this article as I usually do to our viewers and listeners from the New York Sun. It's A.R. Hoffman. He has taken over basically all the reporting for the Sun on this case, and he does an exceptional job. Par excellence here. So he says one thing that I want to make sure we get in here, because we've talked about various things that could happen, but again, the standard is the appearance of impropriety, right? And so what Trump's legal team is ultimately doing here is focusing on all of those elements, not only that were shown to Judge McAfee during the evidentiary hearing and the deliberations and all of that. Rather, they are focusing now more on the phrasing and the words and the things that he said in his order that directly contradict the holding, right? The finding that he made, the finding being that either she has to step off or that Wade has to step off, but both of them can't remain in the case. And the fact is, they discussed the fact that Judge McAfee actually looked at what would be, I think, considered forensic bias or something like this. Have you heard of that before, Norm?
Now, it sounds like something they'd cook up in Georgia with, peanut oil chicken, or you're boiling your turkey in peanut oil. Only in the South would they come up with something like that,
Forensic misconduct. So here's just a quick excerpt. Quote, the defendants are likely to press on appeal the position that a speech Ms. Willis gave at Big Bethel AME Church in honor of Martin Luther King Jr. Day amounted to, quote, forensic misconduct because it accused her foes of, quote, playing the race card. Judge McAfee found that oration was legally improper because of its potential bias to potential jurors. He ruled, though, that it did not cross the line sufficiently to merit disqualification.
I agree with McAfee on that. That's a stupid argument, and they shouldn't waste ink on that. The extrajudicial comment, the line of cases. Oh gosh, Gentile versus the State of Nevada Bar Association is the lead case in this area. And it involves application of a rule that prohibits a lawyer from making extrajudicial, that is, out of court pretrial statements before court that are substantially likely to have an impact on the proceedings, on the judicial proceedings. And Fani's comments, frankly, don't meet that standard, in my opinion, and no reasonable jurist would conclude that they do. Should she have been out there running her mouth in that way? Candidly, I think she has a right to do so. She has a right to speak and to defend her reputation. Did she say that close to the time of trial? No. Did she say it in a way that creates a substantial likelihood of affecting the fact finders, the jurors in this case? That may be a closer question, and I don't know the record in this case well enough to reach that conclusion. But the more fundamental issue for me, and I urge the Trumpistas to press this, is whether a prosecutor about whom there is good reason to believe engaged in lack of candor to the tribunal can be a minister of justice at all, if her lack of candor involves statements about this case. Because, in the end, she's going to present the people's case. She's going to stand before a juror and with the imprimatur of that office and ask the jury to follow the law as she understands it. And there is trust imputed to her. And having shown herself to be untrustworthy, she should be removed from the case.
And she's on her own now. I think that, that's just my observation. I think that with Wade sort of moving away from the case and her continuing to press forward, I mean, the Trump team is also going to argue that she's made this she's achieved a sort of personal stake in her involvement in this case. And I think that that's very accurate, but I find it objectionable that she's remaining in this case with all of this circulating around her. I'm not suggesting that people in her position don't have difficult decisions to make, or that they aren't, they shouldn't look at criticism and take it for what it is. But this is something different than the public wanting certain outcomes based on their own personal biases. As we've talked about ad nauseum on this stream, Norm, the appearance of impropriety is the legal standard that has been met and gone far beyond.
Yeah, I think that's right.
So the fact that she is willing to remain in this case with that stain, with that controversy, says a lot more about her character than I think it does anything else. So I'll leave it at that.
Quick response to a question from Dawn McNeil. Should I ask AI to fill out my NCAA bracket? And I say, yeah, Dawn, go into ChatGPT-4 and ask it to rank the teams. That would be a fantastic experiment. Create a bracket on that and then report to us. I want to see if AI gets it right. Will that destroy the betting market if it does?
Ask Grok. Use X. Ask Grok to fill out your bracket. I want to know the difference between the two. Do ChatGPT-4 and then do Grok, and let's see who wins.
And let's talk about that for a moment, because that actually is such a profound question. Assume that the universe is simply composed of matter and motion, which is the materialist assumption that motivates so many people. If that's the case, then enough data about the past should be able to predict the future, because each molecule, each atom will move, each subatomic particle will move in a direction in response to cause and effect. But wait, you say, what about quantum mechanics? And what about movement at a distance? And what about Heisenberg's uncertainty principle? What about the fact that the table that you're looking at right now is actually composed mostly of moving parts, moving things, matter and motion, but yet it appears solid to you? So, if a sufficiently powerful computer should be able to look at matter in motion and predict it every time. And once it gets to that point, the joy of living will be gone, because the reason we watch the games is we want to get sucked up in the drama. We want to see how chance and circumstance unfold. We want to see how the players respond to challenges. We want to have a heroic struggle toward an unknown ending and the satisfaction of our hero winning or the devastation of our hero losing, because that's how we experience life. And so, Dawn, great question. Do your bracketology, report to us, and let's see. And Mike, great suggestion. Whose product better approximates reality? Grok on X, ChatGPT-4, or is it just Mike and Norm navel gazing every morning? You don't need artificial intelligence when you've got us, or maybe you need it even more when you've got us. What else do we have this morning, Mike?
So we've got, this is sort of the headline, and we've only left ourselves a few minutes here to talk about it, but it is the First Amendment before SCOTUS. So broadly, we've got what was Missouri v. Biden, which has evolved into Murphy v. Missouri, and then we've got the Linkey v. Freed case, which is more about elected politicians, and the use of their private social media for public means or as a profession, and then the censorship or removal of constituents from comment sections and replies and stuff like that, locking their account, in other words. And that latter concept was really debuted with Trump, right, when he started receiving legal scrutiny and lawsuits around removing people from his social media during his presidency. But I think the one that we really should spend time on, Norm, is Murphy v. Missouri, which
let's get to it. I mean, this is the practice of jawboning. I cut you off, Mike. I can see the roll in your eyes. Like, shut up, Norm. All right, go ahead.
No, I was actually prepping a video because I think that what many people want to talk about is Ketanji Brown, Associate Justice Ketanji Brown Jackson's remarks during oral arguments yesterday.
Let's jump right to it. So this is a case about jawboning. Federal government has to the degree that it puts pressures on social media company to control its content, to eliminate misinformation and stuff harmful to the administration's view of what's good for the public. What role is it proper for government to play that role? Is it proper to threaten or imply that they will threaten companies with adverse action unless they listen? What role does the First Amendment have? At the bottom line, that's what's at stake in this case. Listen to what Ketanji Brown had to say when First Amendment issues were raised.
This is the first of two videos here.
Well, she did have something to say, and it wasn't, I don't know what a woman is. There was a justice, had a name. Ketanji was her name. Oh, no, she didn't do that. No. So anyhow, basically what so what we have is a First Amendment. We have
you not hear it?
No.
Oh, okay. Well, then maybe that's the issue. All right. So we won't play it now. Sorry, everybody.
So basically, go ahead. What did she say?
So she expressed two separate ideas. And maybe this will help. Now can you hear it?
Tailored its regulation.
Yes.
Okay, I'll rewind here. Sorry, everybody. That was my fault.
But whether or not the government can do this is something I took up with Mr. Fletcher, depends on the application of our First Amendment jurisprudence. And there may be circumstances in which the government could prohibit certain speech on the internet or otherwise. I mean, do you disagree that we would have to apply strict scrutiny and determine whether or not there is a compelling interest and how the government has tailored its regulation?
Certainly, Your Honor. I think at the end of every First Amendment analysis, you'll have the strict scrutiny framework in which, in some national security high.
Just cut to the chase, Benjamin.
Able to demonstrate a compelling interest may well.
This is bad argument. This is sucking up to the judge. He's trying to think of what his answer is.
In which the government.
Well, and then what she really hinges on in this first clip, Norm, is trying to cut him off because if you recognize that he said at the end of every analysis there is that compelling interest framework and the narrowly tailored, and what she is pushing him into is she really is kind of playing bully ball with this concept of compelling interest and narrowly tailored, which is the strict scrutiny framework for those unfamiliar with First Amendment analyses and state action. And that is at the heart of this case, Norm. We're talking about whether government coercion and persuasion and backroom pressure being applied to social media platforms such as Facebook and Twitter, etc., is de facto state action for purposes of application of the First Amendment, right? And censorship.
And then what did she say about the First Amendment?
And so what she said about the First Amendment in this context was, well, there are circumstances where the government, can censor. And so I'll go to the second video specifically for that, right?
Justice Jackson?
So my biggest concern is that your view has the First Amendment hamstringing the government.
Absolutely.
Can you imagine?
Where'd you go to law school? Crackerjack you? That's the whole point of having amendments to the
Constitution. Can you imagine?
There are limits beyond which the government can't go.
The cognitive dissonance required to be an associate justice of the United States Supreme Court and this is perhaps the biggest First Amendment case of a generation, right?
How did John Roberts not take his gavel and toss it down?
I'm going to rewind it. We're going to do that again, but here we go.
Justice Jackson?
So my biggest concern is that your view has the First Amendment hamstringing the government in significant ways.
Oh, please don't do that. Trust and obey. There's no other way.
I mean, what would you have the government do? I've heard you say a couple times that the government can post its own speech, but in my hypothetical, kids, this is not safe, don't do it, is not going to get it done. And so I guess some might say that the government actually has a duty to take steps to protect the citizens of this country. And you
bring us a public health state.
Duty cannot manifest itself in the government encouraging or even pressuring platforms to take down harmful information. So can you help me? Because I'm really worried about that because you've got the First Amendment operating in an environment of threatening circumstances from the government's perspective, and you're saying that the government can't interact with the source of those problems.
And Your Honor, I understand that instinct, and I guess what I tell.
And I mean, look, I think that you're right. Somebody with a little more force and self-awareness, and no disrespect to Benjamin here, but
he looks about 9 years old. What's he doing in the Supreme Court? Looking for his cover book?
So I've got a couple of issues that I'd like to spotlight on this. Number one is that, if we zoom out and we talk about the southern border crisis, right? And then we talk about online censorship and then the COVID era lockdowns and government shutdown. The opposite things that the government should be doing appear to be what they're actually doing, right? So in the case of the southern border, we know that the federal government is actually not enforcing border protection. It's not precluding people from being trafficked across the border. It's not taking steps necessary to stop the incursions of millions of people across the border in a manner that defies reason and logic. And then in the case of COVID era lockdown censorship, it took a monolithic approach to surveilling social media and then applying pressure to these companies. And what Justice Alito said, which is not in the clip that I shared, but what Justice Alito began by saying is that it's difficult for him to rationalize this being the case as applied to the New York Times or something to that effect. That he can't understand how this is not state action when something taken in parallel to that would be state action. And what I think was interesting about what Ketanji Brown Jackson is saying is that she's not even necessarily hiding from the fact that it was state action. It feels much more like she's attempting to justify based on some sort of like inherent superiority of the government's knowledge, right? As if the government is out here with a benevolent inspiration, and it is seeking truth, and it is seeking to disseminate truth as a capital T singular entity to all people affected by some sort of crisis, as if the First Amendment isn't designed to ensure, again, not to the exclusion of other things, but to ensure that the marketplace of idea is healthy and that new ideas can surface for consumption.
Well, I mean, so I think basically what she's trying to do is make truth into the speed limit. We have laws on highway safety. You're not free to drive however quickly you want, even though it's your car and, my car myself. But I think what she's saying is some ideas are dangerous and government should have the ability to censor them, in particular with respect to COVID. If you're not endorsing the public health community's view of best practices, then you're undermining the public's health. And you may be. And I remind people, you'll soon hear, I think, episode 5 of our piece on our series on constitutional law, discussion of the Youngstown Steel case. That is Eisenhower's seizure of the steel mills during the Korean War to make sure that they weren't hobbled by strikes. And there was a question under the separation of powers doctrine, is that a presidential power? And the Supreme Court said, no, it's not. And it reminded people that the purpose of our federal constitution was not to create an efficient government, but to create a government that protected liberty. And those liberties, I would submit, ladies and gentlemen, are more significant in the First Amendment context than anywhere else, because the power to choke an idea to death is the power to define reality. And the arts, for example, are a place of tremendous expressive freedom. In politics, we have expressive freedom because what we are, what we think, our passions, how we engage with the world defines ourselves. And letting the government step on that in the name of public safety is treating ourselves as though we were just automobiles on a car. Or on a highway, and giving the government the ability to determine how we can safely express ourselves is the very premise of dystopia. And I've said this 1,000 times on the show, so permit me to say it 1,001. Go out and reread Orwell's 1984. Go out and reread Aldous Huxley's Brave New World. Go out and reread Lowry's The Giver. Go out and reread Handmaid's Tale. In each case, what you have is a community where those in the know have the ability to set standards on the good life and to keep people safe. And in each case, the protagonist breaks out because we crave more than safety, significance, and the ability to go our own way. And so this case is vital.
I just recall the oral arguments during COVID when we had a current Justice Sotomayor, talking about how many hundreds of thousands of children had perished completely erroneously. We're talking about the court that was actually a victim of mainstream narrative news on the topic, and actually taking those pieces of information into oral arguments and trying to arbitrate between counterparties on issues as structural as these. That is crazy. And now we have Ketanji Brown Jackson saying that she's worried that we're trying to hamstring the government with the First Amendment. And to me, Norm, those two things must be acknowledged together, right? That there's this concern or this worry. It's sort of a motherly worry for health and safety, but society is not organized around principles of safety, as you just said. And as you're suggesting that we should read these seminal texts on the topic, right? Even if they're fictional, but seminal texts on what are the logical extremes of this sort of cultural rot, really.
As the Too Much Pussy case told us this morning, the line between fantasy and reality is not as bright as you think. If you can imagine the world, someone is living in the world you're imagining. And the imagination, the ability to face the future with audacity, with creativity, with the certain knowledge that your ability to respond is finite, that the world is infinite, and that all lives come to an end, and that what is required in life is the courage to be in the presence of the unknown. That's the sweet spot in life. and you get a knucklehead up there like Ketanji Jackson Brown saying that the First Amendment can be dangerous, my view is, damn right. That's what it's supposed to be. You know, I'm not going to go 55 I'm not going to go 55 when I'm in a hurry to get where I'm going. I'll take the risk and I'll pay the ticket if necessary, because in the end, government is a convention. You know, I had it out with a client the other day, brilliant guy. And he's always got ideas about how to manage his case, and sometimes they don't work. So I had to tell him, look, you're regarded by many people as a genius, and the client is. But I said, what you need to realize is that the rule of law governs the bell-shaped curve. We have rules, and those rules govern 80-90% of the conduct that we see. There are things that are real. What?
That's so profound.
I'm so deep. There are things at the tails that are true and that matter, but you're going to get yourself in trouble with the rule of law when you behave in the tail. If you're going to live within the law, you need to live in the shadow of the bell. Now, this means, remember the line from Bob Dylan: if you're going to live outside the law, you must be honest. That's what he's talking about. If you're going to take the risk to go outside the bell-shaped curve and live in the tail, the ordinary rules may or may not apply. In other words, they may or may not explain your conduct at particular moments. Your only salvation at that point then is honesty. Because when you're outside the bell-shaped curve, when you're outside the shadow of the curve, when you're living on the tail, the only thing that stands between you and disintegration is integrity. And integrity matters in a crisis. And so, Ketanji Brown, please don't make my world too safe. I'm not looking for safety. I'm not looking for safety, Ketanji. I'm looking for significance. I want to be fully alive in my own skin. And I think that explains the populist impulse in the United States right now. People are coming out of their skins because they don't have a sense of significance in their own communities. And this is why we end up with candidates like Donald Trump. Now, those who want safety and are prepared to take the narcoleptic plunge, they go to Biden. But those who want to be alive are responding to the vitality of the man. And that's my claim, and I'm sticking with it. Hey, I see we've talked ourselves through our time. How did we do that? I
have no idea. Just going to plug you Thursday evening, March 21st. You'll be competing in what's called the Comics Roadhouse stand-up contest at the Mohegan Sun. There are tickets at comicsmohegansun.com. That's comics, COMIX, mohegansun.com. I'm not sure what the price of the tickets are, Norm, but
I think they're $10. And it's a lot of money, but please come out and support me. I think that stand-up comedy will save the world, frankly. I think that the ability to engage intellectually, openly, passionately with your heart, mind, and soul to the presence of ambiguity in the world and to find your way when the shadow of the curve fails, that's the future. And comedy is our way out of the binds that we're in now. Come on out. You'll hear a story about Helen of Troy at age 65 and the transforming impact of things that can never be unseen. I'll see you at the Comics Roadhouse on Thursday night at 10 o'clock.
You can find us here every morning, Monday through Friday at 8 a.m. Eastern Time on X, YouTube, and Rumble at LawPod Daily, or if you're on Rumble, Law and Legitimacy. And that's on the days that it wants to start on time. Other days, it is what it is. You can also find us after the stream every day, audio only, on Spotify, Apple Podcasts, Google Play, Overcast, wherever you find premium podcasts. Please leave us 5 stars and a nice review. Give us a hashtag AMF Yo-Yo, maybe. Go leave us a review.
Let's start doing that. That's our hashtag, AMF Yo-Yo. Stroke of genius, Mr. Boyer. So I'm off to court where I'm arguing on reduction of a bond of $5 million for some nominal offense. And in the afternoon, I'm going to have fun. I'm getting interviewed by a television producer and his crew about an old case, the 1997 case of State of Connecticut versus Tanika Jenkins. Look that name up, Tonica Jenkins, Jenkins. Read the story and then say to yourself, OMG, did that really happen? It's right up there with Too Much Pussy. There are more things in this world, Horatio, than we can easily count.
AMF Yo-Yo. See you in the morning, Norm.
AMF.
Bye, everybody.